So,
You're
I'm
going to
gonna do that
represent
today.
yourself?
Yes, sure. I did serve it with the courts.
Okay, what are we doing?
File with the courts.
Oh, no, I saw.
To begin, I'd like
So what do
to
you
just
want me
announce
to
a brief
do
summary
with
of
your
the
case
incident that
today?
happened.
Pardon?
Well,
The
on
incident.
October 11th, the reason why I'm here, I would just like to a few things. Announce a brief summary of what happened. My
And
bond
that's going to
conditions
get
lifted.
us where?
Well, I did file a motion a couple weeks ago. I don't know exactly what the procedures here. As you
Yeah,
know,
no,
that's wrong.
I know.
Did you
get the discovery? As everything went through, I could
But
tell
I
you
don't think I
didn't know.
properly served it on the prosecutor. But I'm trying my best to do things right today. But I did serve it with the courts.
You haven't started out well.
File with the courts.
Oh, no, I saw. So what do you want me to
I'm here
do
because I'm
with
told
your
to be here
case
today. Your
today?
Honor. That's the only.
I know.
Well, so what I want to do
kind of goes out in my name. So yes, I know why you're
I
here.
want my bond conditions lifted.
You want to represent yourself
I want a
in
discovery.
this?
Yes, Your Honor. I don't know
You don't
exactly
want
what
help?
the procedures here is. You know that wrong.
Okay, I know, because as you're talking, I'm going to do this. I'm going to apprise you if you wish to represent yourself. You're
But I'm trying my
constitutionally
best
entitled
to
to
do things
do
right.
that. I will
but I just,
apprise you that you are
okay,
before the court out well. On the charge of resisting and obstructing a police
I'm
officer.
here
You
because I'm told to
understand
be
that
here today,
charge?
Your Honor. That's the only.
I know.
All right.
I know. That is a felony. Kind of comes out in my name. So yes, I know why you're here. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor. I do.
You don't want help?
No.
You also understand, sir, that there can be great peril in representing yourself. I'm going to apprise you if you wish to represent yourself. You understand also that at this proceeding and any other further proceeding, you that the court is going to hold you to the same standard the court would hold anybody else to. The court will not play favorites. So you understand that charge will not be assisting you. All right. You understand that is a felony or a high court misdemeanor. If at any time you wish to be represented by an attorney, incarceration, you cannot afford to hire an attorney. But if you wish to be represented by an attorney, the court will afford you that opportunity. You also understand, sir, that there can be great peril in representing yourself.
In trial. I understand.
You understand also that at this proceeding and any other further proceeding, you request the court is going to hold you to the same standard the court will hold anybody else to. The court will not play favorites. The court will not help you out. The court will not be assisting you. If you cannot afford to hire one, the court will make sure that you have one. All right. If you wish to get another, get your own attorney represented by an attorney, that opportunity you cannot afford to hire an attorney. You understand that. But if you wish to be represented by an attorney, so what do we wish to do today? The court will afford you that opportunity to be represented. You understand that.
First file that process is throughout the whole discovery and trial of this evidence. Until
suppression of what evidence?
Body cams,
request an attorney
footage.
On what basis would you be doing that?
Miranda versus Arizona.
The court will at that point, if you cannot afford to hire one, the court will make sure that you have one.
That I was not
if you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
Because of that,
so what do we wish to do today?
That I could have possibly done. I would like to impede first file a request for suppression of this evidence until suppression of what evidence? To be read my Miranda rights, squad footage, and know that anything that I say can be used against me. Miranda versus I was not notified.
That's your basis. Which says what?
To suppress my
to suppress the body cam.
That I was not read my rights court to see. I'm trying to. I don't want it prior to being public detained. I don't want it, and because it happened. I was on the scene violations. Police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what you're going to have to put more in writing for me to even understand that, because as it stands here right now, based on what you told me,
to be read my Miranda rights,
deny your motion
and know that anything that I say can be used against Miranda. I was not notified.
That's your basis. Your motion to suppress the body cam.
Maybe I'm trying to formulate my to see. I'm trying a little more. I don't want it to my in the public domain. I don't want conditions, but anything that happens and that others. I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know office for discovery. You're going to have to put more in writing for me to even understand that. How do I get stands here right now?
No, I will be doing that.
You ask anybody how to get discovery. I'm going to deny your motion.
I asked a couple of the clerks. Deny my motion. They can't. Under Miranda, give too much legal advice, so I'm trying to take as much responsibility for this as I can. Maybe I'll formulate my request a little
deny
more
that motion
precise
because there hasn't even been a
specific,
request for discovery.
conditions.
If you don't get something,
also
then
I'm
you bring a
requesting
motion for
that there's
discovery.
full discovery
Next thing
in
you
this
want to do.
process. Discontinue all
Have you sent a request to the
hearings until
prosecutor's
there's
office for
substantial
discovery?
evidence on file. I have not.
Okay, that
Have
doesn't
you
happen
asked
that
them,
way.
how do I get
I
discovery?
don't know what
No, I will be
discontinue all
doing
hearings
You
that.
ask
means.
I don't
anybody
know
how to
either,
get
Your Honor.
discovery?
I just represent myself over here. I'm just, they can't.
This is going to be a long process if you
You know,
just
give too
throw
much
stuff
legal
out there.
advice. So I'm trying to take as much. I tried responsibility as best as I can. I'm really
Okay, this was your best. Well, I'm gonna. You may want to consider that motion because I'm going to let you go because you have a constitutional right to do it. If you don't get something, then it's going to be a long, arduous process if we're going to go at this rate.
Discontinue all prosecution hearings until there's substantial evidence on file.
Okay, that doesn't happen that way.
I
don't know what
you're asking me
discontinue
for
all
what
hearings
I
means.
want. I don't know either. Your Honor.
I'm asking you what you
just
want to
represent
do
myself
today.
over here. I'm just.
This is going to be a
home and
long
have all charges
process if you
lifted.
just are throwing stuff out there.
Okay, so
I mean,
really,
what do I
try to
going
do my
home
best
is
for
an
this.
option.
I'm really.
Okay, this was your best. The charges are you may want to consider getting an attorney,
And,
but I'm going to let you
that's
go
the end
because you
goal
have
of where I
a
want to
constitutional right
be
to
one
do
day.
it. But this is going to be a long, arduous process if we're going to go at this rate.
What is the prosecution expect next in this case?
He says he wants to represent himself. If he wants to talk to you, then
You can almost hear the prosecutor trying to stay polite. The phrase, for lack of a better term, is lawyer speak for this filing makes no sense. This is a great real-world look at why motions must be precise. If you submit vague or redundant filings, the court doesn't even know what to respond to. So here's a question for viewers. Do you think courts should require a short training before allowing self-representation?
I am from the Public Defender's Office. I'd be
And then I'll
happy to
recall
provide
your
past
case in the next slide.
he says he wants to represent
And then
himself.
maybe
If he wants to
between the
talk to you,
time
then
I leave
yeah, I mean, I
dispatch and
know,
come back,
Mr.
you'll
Getty,
figure
and
out
I
exactly what you
appreciate
wanna
it,
do.
but
Yeah,
And maybe how to do it.
I'm not sure what you're asking me. What are
Or
my
maybe if you
options
want an
here?
attorney to represent you to help you through this process.
What do I want to do?
Otherwise, this thing could go very quickly, go south for you.
Yeah, I understand.
Not be good, but I'll let you think about that. That's your call. I will call the
Okay.
Spanish case up afterwards. I will also then call the one plea, maybe, that we have.
Daniel Magoo.
And then I'll recall your case in the
Your Honor,
next
when the court
spot.
passed this case,
And then maybe
the
between the
defendant didn't hand me a
time I
copy
leave
of
this
his
bunch and
motion.
come back,
I
you'll
took
figure out
the
exactly
recess of
what
the
you want
court
to do.
to
Yeah,
file a
I'll-
response
and
and hand
maybe how
delivered
to
it to
do
the
it.
defendant.
I'll do that.
As
Or
well
maybe
as
if you
handing
want an
copies
attorney
of
to
the court.
represent you to
If I
help you
may,
through this process. Because otherwise, this thing could
Thank
go
you.
very, could
So,
go
this
south
motion
for you.
was sort of
Not be good, but I'll let you
put
think
in
about
three
that. That's your
different
call.
All right.
sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. When the court passed the first motion was to compel the defendant to hand me a copy of his motion. I asked the court to deny that, as the court is well file a response and then delivered it to the defendant, as well as send them a ruling out. If I may, do you want to do one at a time?
let's do one at a time.
Okay, thank
All
you.
right.
So,
You got any
this motion
response to the
was
people's
sort of
response?
put in
Not
three
for that.
different
No, motion
sections, for
denied.
lack of a better term. The second request to all, 1 through 11 discovery were the same items. So I only responded to that middle section, which was the motions and different discovery items, as well as was to compel the testimony of officers at a deposition. I'm asking.
Ooh, that's brutal honesty from the bench, and it's rare to hear it so unfiltered. The judge is walking a fine line, protecting the defendant's right to self-representation while making sure the trial doesn't become a circus. It raises a bigger question. Should judges step in more when a defendant clearly doesn't understand the process, or would that cross into giving legal advice?
His request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I request an opportunity for review. Number 3 was to give us something that's fine, but appears to be a request for people to get medical records for some person and give those to defendant. I responded that it is that request was unclear, but it appears to be that the people execute a search warrant.
Here's what I'm going to do, at least at this point, is I'm going to deny the motion. That portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely. Thank you so much.
Your Honor, in
Number
response to
3 was
that,
particularly troubling to the people, as it
I have
appears to be a
FOIA
request
records,
for the
naming,
people
well,
to get
describing
medical records
the,
for some
witness,
person and give those to
and
defendant.
his shirt
I
that he was
responded
wearing,
that
which
it
is the
is
reason
that
why
the request was
the
unclear, but it
deputies or
appears
the
to be that
detectives
the
were
actually the search warrant
dispatched to
contained
the
medical
paparazzi
information for an alleged witness who does
parking
not
lot
appear to be mentioned in the
at
police report
2
currently in
3
possession of
a.m.
people.
that morning.
Unless otherwise directed by
I
the
also
court, people
have
would
a
think that
picture of
don't intend to
the
execute
witness
search warrants,
being
private and
right
potentially
there when I
privileged
got
medical
arrested.
information for this person.
I mean, I can show you it. It's quickly available Your here for
Oh,
me
in
to
response
show you.
to
But,
that,
I mean, he's really within. I have
I
the
really would
FOIA
be
records
the defendant showing anything before, but he has not disclosed to the
describing
people.
the witness. Given that I do have FOIA on his shirt that he was wearing, which is the reason why the dispatch deputies or the detectives when they were dispatched, they made comments saying the paparazzi. There's a Huron Valley ambulance at 2 or 3 a.m. that morning for a person due to high intoxicants. Picture of I wasn't dispatched the witness to Huron Valley, but this is in my right there when I got arrested. Valid enough to say that he is a part of the same. I mean, I can show you it. It's quickly available here for me to show you, but I mean, he's really within.
I really would be
the grasp.
the defendant showing anything before, but he has not disclosed to the people.
I've known him for 15 years. Given that I do have FOIA on my the course of the CAD record and for the dispatch record was police when they
You want
made
his
comments
medical
saying
records?
there's a Huron Valley ambulance him to get his dispatched for a person due to his witness statement on. I wasn't dispatched to Huron Valley, but this is, and I would also like this is valid enough to say that he is a part of the same due to the nature of why they.
I'm not going to order.
Scenery.
I mean, that is. I'm not going to order medical records.
Do you have a name?
His name is Jacob
Taylor.
Spalding. I've known him for
A
15 years.
request for something that
Was
isn't
with him
available
throughout
in
the course
another
of the night,
fashion, and that's fine. But I'm going to deny that.
So yeah, a lot of my
you
civil
want his medical
procedures,
records?
I will be correcting and first of all subpoena him with to get his witness. But as for right now,
Your civil
to
procedures.
get his witness statement, I'm trying to follow the rules of federal civil procedures and officially.
A federal.
And I would also like this is.
Yeah.
I think so.
Okay,
his
so we're
records due
state
to
court.
the nature of why they
I'm
try
not
to
going to order.
oversee.
I mean, that is. I'm not going to order medical records. You might want to start there. You, Taylor,
That 3 is denied.
a request for
3 is
something
denied,
that
Your
isn't
Honor.
available in another
denied,
fashion,
yes.
and
Thank
that's
you.
fine, but I'm going to deny that motion.
Number 4 was
A lot
to
of my
subpoena a witness.
civil
I just
procedures,
responded
I
that the
will be
defendant
correcting
should
and
follow the
will
subpoena
not
process
have any more
available to
problems
him.
with. But as for right now,
Okay.
Your civil
The defendant was, the
I'm trying to
defendant
follow
is
the rules of
requesting the
federal civil
report,
procedures.
produce
and
all
this is
audio or video
federal.
recordings. I said he
yeah,
should go
this
through the
is-
discovery
yeah.
process. That's
so.
the motion.
Okay, so
That's
we're
fine.
state court.
Okay.
It's denied.
I'll try to
Criminal
Number 6,
procedure.
Thank you
this
so
is the
much.
people, I'm not exactly
Yeah.
sure.
So you
This is
might
a
want to
motion to
start there.
seal statements.
Okay. I don't know what that means.
That 3 is denied.
What does that mean?
3 is denied, Your Honor.
The whole
means
motion
any
is denied,
statements that I
yes.
made,
Thank you.
All three parties.
under stress.
Number 4 was to
to either the
subpoena
police
a
officers when they were
witness.
questioning
I
me,
just responded that the defendant
or,
should follow the
before,
subpoena process
after.
available to him.
What do you want to do with them?
Okay.
I
Number
would
5
like to
was
suppress
the
them
defendant is requesting the report
so that
produce
they
all
don't,
audio or video recordings. I said
hinder
he should go
my
through the discovery
trial
process.
experience,
That's that motion at this
as I
point.
was not
What does that mean? It's denied.
Thank you.
I
Number
was not
6,
given
this
proper
is the
notice of
people,
my
I'm not
rights when
exactly
I
sure.
was detained,
This is a motion to
and I was
seal
questioned thoroughly
statements.
afterwards.
I don't know what that means.
I don't
You have to lay out
What
does that specifics as to how
It
and
means
or
any
another,
statements
any
that I
statement
made,
sound to me like was the
under
subject matter
stress,
of necessarily
to either
an
the police officers
custodial
when they were questioning me,
interrogation, but it
or,
doesn't really matter.
before,
You're gonna need to lay
after.
out all the elements of
What do
that
you want
before I
to
would
do with
rule on
them?
that. But in its
I would
form
like
as
to
it sits right
suppress
now,
them
that motion's denied
so that
without
they
prejudice.
don't
My
hinder
response to
my
number 7,
trial
which is the
experience.
defendant is notifying the
as I
court of
was not
exculpatory
really-
video
What does that mean?
evidence. Okay.
Well, I was not given proper notice of my rights when I was
Don't
detained,
have
and I was
any
questioned
response to
thoroughly
that.
afterwards.
You have to
Really
file
beyond
a
the fact
motion,
that-
you have to lay out
It
specifics
seems that these
as
are
to
videos
how
the
and or
defendant
another,
has,
any
and then he
statement
hasn't
sound
received
to
any
me
videos from my
like was
office
the
yet, so I
subject
don't see
matter
how.
of necessarily an custodial
I have
interrogation,
videos
but it doesn't
any
really
piece of
matter.
this.
You're gonna need to lay out all the
I have
elements of that
videos
before I
on
would
both
rule on
FOIA
that.
requests
But in its
from
form
the
as it
Police
sits right
Department
now, that
and my own.
motion's denied without prejudice.
I would just, I was
My response to number
formalizing
7,
the
which
process
is
for
the defendant is
prosecutor
notifying
to
the court of
build her
exculpatory video evidence.
prosecution.
Okay.
Do what?
When I requested discovery
don't
items
have any
that I'm going
response
to
to
do
that.
following the
Really
rules
beyond
of
the
civil
fact that
procedure.
It
That's what I
seems
was.
that these are videos the defendant has,
So-
and that he hasn't received any videos from my office yet, so I
This
don't
last
see how
one, what are you gonna do with
I
that?
have
What do you want the court to
any piece
do?
of this.
I want the court to. I have videos, both FOIA requested from the discovery and my own process that I'm guilty of these crimes. I would just.
Okay, so
I was
it doesn't,
formalizing the process.
you
for
seem
the
to want this
prosecutor
process
build
to
her
work away, it doesn't.
prosecution. Maybe
To do
maybe I
what?
could be in pro se. When I requested
Yes, there are
discovery
huge
items
disadvantages
that I'm going
because
to
I
do
think
following
you
the
think you
rules of
know
civil
what you're
procedure.
doing, but you
That's what
don't.
I was. Yeah.
It's become readily clear to me. You have no idea what you're doing. Last one. And so I'm going to ask you going to do with that. What do you want to cause some difficulty for you?
I want the court
So I'm going to
to
ask you again. Do you wish to be represented by an
find on what
attorney?
grounds.
Motion denied.
Throughout the discovery
Number
process
8,
that I'm
defendant
guilty of
requests the
these
court
crimes.
cancel all
Okay,
current
so
bond
it
conditions
doesn't-
pending the.
Motion You seem denied. to want this process to work away. It
Motion to continue
doesn't.
proceedings. People weren't opposed to
Maybe
adjournments,
being pro
but
se,
this is actually kind of
Yes, there
several
are
things.
huge disadvantages
The request
because I
is
think
to
you think you
continue all
know
six
what you're
hearings until
doing, but
requested
you
testimony, evidence,
don't.
and hospital records are provided.
It's become readily
So I don't
clear
have an
to
issue.
me. You have
if the
no
defendant needs
idea
more
what
time to
you're
be
doing.
prepared to have hearing,
And so I'm going to ask
but
you.
I do have an
and-
issue if
and it's
he's
gonna
trying to
cause
say
some
that he can't
difficulty
do
for
anything
you.
until we.
So I'm going to ask.
Whoa, that's the judge's polite way of saying you're in way over your head. This is one of those moments where self-representation sounds noble, but legally, it's a minefield. The defendant hasn't even filed for discovery yet. That's like walking into a sword fight without the sword. Should judges let people represent themselves when they clearly don't grasp the basics?